How you doing, everybody? Daniel Gaines here. Real quick, just to give an update. Even though the video is posted of the hearing, like I said, I was denied. Again, no legal anything can be cited. They're incapable of citing any legal justification or reason. Instead, they claim we have jurisdiction. How do you figure? I've sufficiently proven a complete lack of, so how do you figure? They won't address it. They won't allow me to bring it up. They won't allow me to question how they figure they have jurisdiction. If you actually go to and look into the judicial canons for the state of Washington, judicial canons are basically the rules that govern what a judge can and can't do. Judges are compelled to comply with their judicial canons and cannot violate their judicial canons. A violation of their judicial canons can and typically will relate to an abuse of discretion or abuse of authority or power, depending on what your state guidelines are. Some states it'll be abuse of power, other states it'll be abuse of authority, some states it can be both. Anyway, if you look at the judicial canons in the state of Washington, Canon 2, Rule 2.6 explicitly states ensuring the right to be heard. What that means is that a judge, commissioner, or anything else in the state of Washington who's bound by the judicial canons must allow the parties in a matter sufficient time to present their case. As you've seen in the video, the judge started out with, "You have 10 minutes, Mr. Gaines." 259 pages of documents were presented and filed in this revision. 259 pages of information was presented to the court. This judge was only assigned 2 or 3 days ago. Literally, just assigned. I know damn well this judge did not have time to review and read all 259 pages of what I filed. So for him to not have a chance to review any of the evidence or the document in front of him, to limit me to only 10 minutes is an extreme violation of his judicial canons, an extreme abuse of his authority. It's also an extreme abuse of discretion. So that's one thing. Another thing is, because he failed to review the documents, he failed to address the bias and discrimination that's clear in the documents and on the record. Because, like I said, if you go back and look at the 2004 matter, case numbers in the videos, I don't hide this information. I want to be fact-checked. Waiting to be proven wrong still. Fact-check me, please. Correct me where I'm wrong. I'm begging you, literally. Help me out if I'm wrong. Again, I digress. If you go look at 2004 case and you look at it in its entirety, you will see not a single piece of financial information was filed. The only thing on record is that Juliet claimed I brought home $2,000 a month at a time whenever I literally just moved back to Illinois because I was put out of my home and had my kid taken from me, at a time when I was unemployed looking for a job in the state whose minimum wage at the time in 2004 was $5.15 an hour. She stated I brought home $2,000 a month. No proof, no anything, and the courts accepted it as fact. Without any financial documentation, she was allowed to have a child support order granted. However, I'm not allowed to have it modified for a lack of financial documents. And then this judge today straight said, you filed a motion to modify with basically saying with the intent to attack it as void, which is not allowable. However, I cited from the filing that's literally right in front of his face, the case law from the state of Washington that says I can do that because it can be attacked directly or collaterally. I filed a child support modification. One has never been done. The court documents states that one can be done every 3 to 5 years, whichever it is. I'd have to look at the document again. I think it's 3 years to be honest. But we'll say 5 for the sake of argument. So if one's never been done, almost 18 years later, that's outside the 5-year time limit, right? Which means I can file the motion to modify. And then according to state precedent and standing case law from the appellate courts in the state of Washington and upheld by the Washington State Supreme Court, I can do just that. I can attack it directly or collaterally so long as I'm proper before the court. My motion to modify was filed properly. The working copy of the proposed order was filed properly, all accepted by the clerks and submitted into the case. I was proper before the courts. Therefore, directly or collaterally, I can attack it. All in the filings. I've shown the case law on these videos. Anybody can look into it. Anybody can fact check this. Same with jurisdiction. They won't get into it with me. They won't get into jurisdiction at all. I can sit here and cite everything under the sun, cite Louisiana statutes. Well, I didn't cite the code, but it's in the filing, so it is on the record. And that, don't worry, my filing, all 259 pages, will be included in the appeal. That's really all I need. I'll have 3 transcripts done as well, but my 259 pages is the only documents outside of those transcripts that's going to be submitted in the appeal. I won't need anything else. The evidence is overwhelming and speaks for itself. Anybody who's not a corrupt criminal can easily see this. I mean, a babe can tell this. By babe, I mean a baby. Sometimes I do use old-time words that some people don't know because they're not commonly used anymore. Can't help it. I'm an oddball. Done too much reading and know too many words. Sorry. Sometimes it just happens. But again, I digress. Sorry, my mind really does go all over the place sometimes because there's so many things going through my mind. I have an odd brain. I process thought quick. I don't forget much. I have an eidetic memory. I actually have had the tests and everything done to confirm this. It contributes to the insomnia, and it's because of these corrupt actors. But anyway, so my mind goes, I bounce back and forth so much because there's so many different things that pop into my head, and yeah, sometimes at times it just comes out. So I digress, and I'll continue to do so. I apologize, but I usually get back to it. Anyway, yeah, they won't get into the lack of jurisdiction with me. They won't allow me to go into it other than citing whatever I want to cite. They won't acknowledge my evidence or anything else, even when it's right in front of them. They won't discuss it with me because they know. Instead, all they do is say jurisdiction was proper. But yet, on the record and on its face, there exists a complete lack of. And the appellate court, I'm extremely confident about the appeal. That's why all of this was built up for the appeal. That's why I made sure that with each of my filings, there was different case law used. It's not repetitive. I made sure that the record is very well established, orally and in my filings. That way, when this goes through the escalation process, it's even easier for the courts to see. There's less work I have to do at that time. But it's all actually factual. Like I said, there's proof of everything I make. I don't make a single claim I cannot prove, or that I haven't proven. And I haven't even made all the claims yet. I've still yet to get into the RICO and a lot of other things. But don't worry, it's coming. The appeals court, as I've stated, is literally second to the last filing I will do. Once this notice of appeal is filed, here, probably in about half hour, 45 minutes, it will start the process of the appeal. Once the appeal is done and the ruling is handed down, I'm not asking for orders to be sent down. I just want the appellate courts to straight overturn it and void the order, which they'll do. At least if they follow their own case law. And I'm nobody special. They're not going to overturn 100 years, 75 years, whatever it is of case law for me. I ain't that special. So, that being the case, this will go to the appeals court, maybe if it has to, if I am wrong. I haven't been yet, so we'll see. But if it has to, it'll also go to the state Supreme Court. Maybe not. I don't know. I'm undecided on that. I kind of don't really want to do the cert because I'd rather just take it to the federal courts instead. And with the complete lack of jurisdiction, legally I can do that. I don't even have to jump through the hoops of the appellate process in the state. Because of the complete lack of jurisdiction, I can file under original jurisdiction with the federal courts because we are dealing with multiple states. Again, today I didn't get into the interference with interstate commerce. because there's case law to support it. Again, it's in my filing. And there's a lot of things that I wasn't able to get into. That's all going to come out. See, these people think it's my opinion, and well, once I tie everything together in the federal courts, they're actually going to have the burden to prove that I'm wrong in these claims. Even though I don't have proof of these claims, I have enough circumstantial evidence to substantiate them, or to have a reasonable person believe them to be true, which is the only standard that there is, reasonable person standard. So I believe the reason they prevent me from talking and limit my time so severely is because of the fact that they know what the record contains. They know all the errors that are on the record. They know that this entire matter is void. They know that the liability on the state of Washington is insanely high, and they know that the damages for all this is going to be a lot higher. They're also very well aware, and this is the important part, the main part, they're also very well aware of the criminality of their actions. See, lawyers and judges, they communicate with each other outside of the courtroom about your case. Whether you're pro se or have an attorney, they discuss your case in judges' offices, and they reach conclusions before they ever go into the courtroom oftentimes, or throughout the trial or whatever. Well, seeing as I'm pro se, I don't have the option of sitting down with the judge in his office and discussing the case like Downing does. So Downing's in communication with these judges ex parte. And don't worry, that'll be proven at the federal level. There will be subpoenas issued for the information to verify and prove this. But I'm going to prove Downing is engaging in ex parte communication, and they're agreeing to a predetermined outcome before the hearings ever start. So they reach these determinations, violate their own judicial canons, violate state and federal law, violate standing United States Supreme Court case precedents, violate Supreme Court case, or go rule against Supreme Court case law, federal appellate court case law, federal district court case law, state Supreme Court case law, state appellate court case law, and everything else. They basically make up the law as they go, and in the entirety of the matters, it's been nothing but kangaroo court after kangaroo court. I've yet to be in a competent court in the state of Washington. Starting from 2015, in Pierce County and Mason County, Washington, I've yet to come across a competent public servant, judge or commissioner. I've yet to come across a competent courtroom, and I've yet to come across something other than a kangaroo court. Again, all proven by the documents. A lot of them's already on here. A lot of the proof's already on here. Fact check me. Y'all have the case numbers. However, I have different hopes with the appellate court. You see, I'll be the first to admit, when it comes to the procedural side of things, my knowledge could be a lot more detailed and in-depth than it is. When it comes to the procedural side of things, my knowledge is actually limited compared to the rest. Now, I know the state rules for procedure, civil rules, at least the ones that apply. I know the federal rules for civil procedure, but I don't know the appellate court procedure and such like that. So, because I can prove that twice now the state of Washington has intentionally blocked my efforts for an appeal by just simply flat out rejecting the notice of appeal when it's been done correctly, and I can prove this. Don't worry, I have the receipts for everything I say. Some things are just will only be revealed after they've been submitted to the federal courts. So why certain things will only be talked about, really, at the federal level. I'm not stupid enough to give them 100% of my hand. To date, I've given them maybe 30%. If that tells you anything. With all the shit y'all have seen me cite and file, only about 30%, and that might even be a high estimate. Literally. Look at the case. Look at all the cases. You'll see. But again, I digress. So I called the appellate court today to ask them if I could just file the notice of appeal straight with the appellate courts, or if it has to go through the superior court. I knew the answer. wishful thinking. But I also wanted to see if the appellate courts were going to give me information as far as the procedural side of things, because according to federal law, that is legit part of a court clerk's duty, is to answer questions about the procedure and policy. They cannot give legal advice. They are not attorneys. But when it comes to the procedural side of things, that is literally their job. So I called the appellate courts and I got one of the case managers on the phone. I was actually impressed. It's the only time I've ever called anybody in the courts in the state of Washington and actually got helpful and useful information. The lady I spoke to was freaking awesome. She was a freaking rock star. So, now that I've got all the information I need for that, I am going to get this appeal filed, the notice of appeal filed and served to Downing. And then I'm going to send the courtesy copy of the notice of appeal to the appellate courts, along with the proof of service for Downing, which will be done through the link system. So there will be a record when the freaking criminal, if the criminal tries to deny it or claim he wasn't given the notice of appeal. Sorry, I got the hiccups a little bit. And then from there, things will play out. There are going to be some fees that are going to come up. I'm expecting probably a couple $1,000s, no more. So, yay, more money I don't have. But again, this is the hill I'm willing to die on. It is going to be covered. Don't have a choice because it's going forward. But yeah, notice of appeal to be filed today. So here soon, I'll have information regarding that. Once it gets to the stage where I have to submit my brief, then I have 45 days to submit my brief. It's not going to take me anywhere near that. It'll take me a day or two at most. So I'm going to try and expedite this through the appellate courts as much as possible. However, there are time limits that are given. So if the other side, like as far as the brief goes, if they want to wait till the last day to file their brief, then there really ain't nothing I can do about that. As far as like the transcripts go from the court reporter, pay them day one. Ask if there's any way to expedite it. See if there's any way you can maybe tip or whatever for all of it to be expedited and done quicker, because they technically have 60 days to get it all done. So, I mean, there are little things that may or may not be able to be done to quicken it up. It's not going to be an insanely quick jump, but it still can be sped up all the same. However, the appeal for this should be fairly simple, as this literally is black and white. There's no gray in this area. I mean, the evidence is overwhelming. It speaks for itself. It's just getting it to a competent court. Typically, most appellate courts are going to be competent. It's very limited to where you'll have to escalate from an appeals court on matters like this. Most times the appellate courts will not let a void order go beyond them because they know of the implications and ramifications it has even further to ignore the evidence and the law. So typically appellate courts is where void orders die and the void orders get thrown out. It's actually difficult to find case law where there's evidence to prove the orders are void and the case wasn't thrown out. Again, fact check me, please. Anyway, I said I was going to give a quick update. Here we are going on over 19 minutes in. So I'm going to go ahead and get off here. Real quick, somebody I encourage y'all to go follow if you're not following. A guy named Jeff Morgan. He's in Texas. He's one that is also trying to get reform and push for reform in the family law courts. He's trying to get the Texas legislature to make 50-50 equal shared parenting time a law in the state of Texas. He's on YouTube. He does court watching and stuff like that. He exposes corruption and all that. Awesome guy. He's somebody I highly recommend y'all go follow. The more people we can get following people like Jeff Morgan, the more we can expose this, and then maybe the faster we can affect real change. I mean, naturally, yeah, I want people to, be watching my videos and sharing my videos to help expose the corruption. But I'll be the first to admit, I'm a crude individual. I have no filter. I do not bite my tongue. And I just don't care. I'm not ever going to be the mouthpiece or the public image in any type of movement for change. I'm too crude and direct for that. But a guy like Jeff Morgan, now he's exactly the type of person that can be the face of a movement like this. He's very intelligent. He's extremely knowledgeable over these topics. He does his research thoroughly to make sure he's presenting factual and valid information. He's also very well spoken and everything else as well. So that's why I say folks need to go follow him. Let's get him some more support. Get his videos out there more so we can expose this more. Also, another thing is court watch. Need court watchers and court hearings, especially as it relates to family law matters. Family law courts are the most corrupt courts in this country. Period. Nothing comes close. Nothing. Like even the corrupt politicians in Washington, D.C., meaning all of them, they can't even hold a candle to the family law courts. It's that bad. Now, the more people that we have watching these hearings, the better, because the more people we have watching, the more people that are witnessing this corruption, and then the more people there are to file complaints against these judges and everything else. And that's what we need people to do. We need people from all over the place filing complaints against these judges for their abuse of authority, abuse of discretion, violation of their judicial canons, violation of law, and everything else. If you've got 500 people filing a complaint on one judge for a hearing because he overstepped, because he crossed the line, well, just one party making a complaint isn't going to do anything. They're going to ignore it. You're just bitter you were ruled against. It's how they're going to chalk it up. It's just going to get filed right in the trash can. But if 500 different people submit a complaint about the same judge for similar issues, that cannot be ignored. Cannot. They don't have a choice at that point but to start looking into things. So the more court watchers we can start getting, the better off we'll be. The more people who will file and lodge these complaints against these corrupt actors, the better off we'll be. And this is all done to try and establish some accountability in these courts and to prevent the extreme violation, deprivation of rights and everything else that takes place. But yeah, with that, I got to send an email with some documents real quick. Again, go follow Jeff Morgan. Other than that, video of the hearings up. Otherwise, that's all I got. I love y'all. Have an awesome day. Peace.